We're here with another episode of Two Lawyers Walk Into a Bar, and I'm joined today by David Kupfer, a partner at King and Spalding. What's up, Dave?
Hi, nice to see you.
Good to see you. You know what's funny? We worked at the same firm for a little bit, probably 10, 12 years ago, but I don't actually know if we ever met in person.
I'm not sure if we ever did.
It took a couple of my goofy LinkedIn posts that you made the mistake of engaging with and then like kind of locked yourself into a quasi-friendship here. How do you feel about that?
I feel like your posts were classic New York litigator issues that you were raising. So I felt like I could jump in and comment on them. So I liked it. And yeah, it's good to know other people that are like real lawyers, who practice in New York.
Yeah, definitely. And I've done a couple of these episodes with other people, and I always make the joke like, hey, you liked my LinkedIn post, so now you're stuck. But it kind of is nice that there's this like cadre of people around the same age group, came out of law school, came up in the litigation world around the same time, that I've met a lot of them. Basically, like we took the LinkedIn flirting to real life. So thanks for responding receptively to that.
Well, you've helped me out a bunch when I needed like somebody for a bond and for a mechanics lien and stuff like that. You've come in handy with a good referral, so I appreciate that.
Oh yeah, you bothered me while I was on vacation for that. I took time away from my family, so I hope that came in. I hope that came in handy. Anyway, you have. Let's see. There's a lot to discuss here. We could go through your background, but I think let's go in a different direction. You and I have had like a little bit of a. I kind of feel like the conversations we have is almost like being on a New York City bar committee where you just kind of like gripe about everything that's wrong with litigation practice. Let me flip it. You practice a lot in New York State Court, right? What do you like about practicing New York State Court, if anything?
Well, this is going to sound like the nerdiest thing I've ever said, but I actually like the CPLR. I like it more than the uniform rules. I think that it makes a lot of sense, and I've enjoyed becoming a student of the CPLR. But I feel like there's opportunities where if you get a lawyer on the other side, even if somebody who practices in New York a lot, who doesn't know it as well as you do, you can really take advantage of that and get some, procedural advantages by knowing what you're doing and how to practice. So I like that to a certain extent, it's predictable and I know how to play the game really, really well. And I think that, we're in a new generation of judges from when I started, and I've gotten to know the judges by practicing before them, the reputations and what they're good at, what they're not good at. So first thing is I feel comfortable and I know how to play the game really, really well. But I think that to a certain extent, it is relatively consistent and predictable in terms of what you're going to get from different people, which I like a lot, rather than going into a place where I don't know anybody and it feels kind of like a circus.
No, I agree with that. There are even some like you're mostly New York County, right? I mean, I feel like there are also counties. We're mostly New York County. There are other counties where I go there and I feel like it's 5 boroughs, but like I don't really feel like this is a home jurisdiction for me, and like people walk a little differently, and there's always the unwritten like layer of how things go. How have you like what do you like and dislike about, New York, kind of like the inside baseball of it? Because there's a lot.
Well, I'm getting more comfortable now with Nassau because I live in Nassau County. So I tell all of my clients who think, should we get local counsel? I'm like, if it was Suffolk, you can get local counsel, even though I can really practice there because
I live in Suffolk and I would not touch a case.
Yeah, I wouldn't touch a case in Suffolk. But Nassau County, I'm like, I live there. I practiced there before. I can get this. I can do this. So I'm getting a lot more comfortable and I have a lot more cases out in Nassau County. And it really does feel like a very small bar in Nassau. So I'm getting a lot more comfortable with that. But I've used my knowledge of New York County to school opposing counsel so many times now. It feels really great. Like the trick about how to get more time opposing a motion when the other party says no, you just file the affirmation in part 130. Back in the day before COVID, you actually show up on the return date. Opposing counsel never shows up because they don't know what you're doing. They think that you've made a motion without a notice of motion, and it's completely improper, but it's the way you're supposed to do it. It's the way it's always been done. So I've used procedural hacks like that to really get what I need when opposing counsel has no idea what I'm doing.
I love the procedural hack because I've done that too. Like the one thing I shouldn't say the one thing, but one of the things I like about New York County is your feet are never really held to the fire that much timing wise. What about I have a couple cases in Nassau. I haven't. Maybe I don't know. Maybe I need to call you next time I get jammed up in Nassau. But I've tried to get some adjournments there, even a week, and I've gotten either resistance from the judge because I guess you have to go right to the judge, or the judge has been like, you get 1 week, nothing more. Like, don't come back to me again. So, what's your compare and contrast a little bit?
I find the clerks in Nassau to actually be very, very responsive and helpful. So if you need something done, you can call the clerks. But if you really need it done, you go to the courthouse and you show up and go talk to the clerks in person. You can get whatever you want. So
Like off schedule, just show up, go into the courtroom,
just show
go
up,
see
yeah,
the park clerk.
and go and just tell them like, I need some help. Can you help me out here? And talk it through with them, and you'll get a lot of
Like
help.
there's someone sitting in the courtroom.
Not in the courtroom, in the clerk's office.
Oh, you don't mean the specific judge's clerk. You
Right.
mean the clerk. Oh,
The clerk's
interesting.
office. Yeah.
All
So
right.
if you need more time, you need an adjournment, they'll help you work through that.
Right. Have you ever been denied in room 130, by the way? This is a debate that we often have. Like, can you, because we've done it a couple times where you go, you put in your thing for more time, 30 days, and then you'll call and say, hey, did you get my thing? And they'll say, well, we got it. We can't tell you what's going to happen. It'll be reviewed on the return date. So you're kind of sitting there like, okay, am I going to get more time? Are they going to jam me up on the return date? What's your experience been with that?
So I had one time where I guess I messed up a little bit because they only have the jurisdiction to extend you up to 60 days or up to 3 times. So one time I filed an application for an adjournment before the 60 days, but I didn't realize that when the return date hit, it would be after 60 days. So they denied it, and they basically told me they have no authority. You got to go to the judge. And so I was left in the weird position where it was fully submitted and I hadn't submitted an op. So I filed an order to show cause that day, and it was fine. The judge gave me an extra 10 days. But that was the only time they've ever denied it. I think if you're within the 60 days or the 3 times, you're good.
All right, so we've gone down a little bit of a nerdy rabbit hole here. So you mentioned to me before we came on that you have expanded your practice to Florida.
Sure.
Let's talk a little bit about what did you have to do? Did you have to? I don't even know did you have to retake the bar? Part of the bar?
I'll tell you all about it.
Is there a CPLR equivalent in Florida that you had to learn? Like, I will tell you before we get in, I handle a few cases in Jersey for a couple of years. I've since moved away from that. At the beginning, it was very cool. Let me learn a new set of rules. But then I was just like, I'm not going to keep up with this, right? It's hard to keep, state and federal are 2 different systems, even in New York, 2 different sets of rules. Introduce New Jersey, and I didn't feel like that's how I was going to best grow my practice. But tell me what your experience has been going to Florida.
Sure. Well, I'm also licensed in Jersey. I did it at the same time as New York. I feel like it's a big money pit. I spend so much money on all of the fees. There are annual fees for this and that. And then if you don't get your CLEs done on time, there's another fee for that.
Yep.
So it's become a bit of a hassle. But when I was at Cooley for a while, I did get a lot of like local council New Jersey things. So I got on a lot of cases I would have otherwise not gotten on because of that. So it was a little bit of an advantage there. But I mean, mostly for the last 5 years, I mostly do real estate and hospitality litigation. So we had a lot of real estate clients that were saying, hey, I got a case in Miami. Can you do it? And they had arbitrations in Miami as well. Now, practicing in Florida, it's like really, really hard as an out-of-state lawyer to practice in Florida. You can only do 3 pro hacks within 12 months. And
In state court.
In state court. And for arbitration, there are actually rules that in Florida that say that if your client isn't in your home state and the case doesn't have a direct connection to your home state, then you can't pro hack into a state law arbitration in Florida. So you need to be admitted there. And while I'm sure a lot of people just ignore that because who's coming knocking, it's an arbitration.
Sure, a lot of people ignore it.
But we got a client that had like 10 matters pending in Florida, split between court and arbitration. I'm just like, I'm going to go get admitted. So it was 2024 February when I took the bar. I did the Catch Me If You Can thing where I studied for 3 weeks and I passed. But it was grueling. It was a lot of work relearning everything. You think you practice for a while and you could just go take a bar. It's not that simple.
Are you going to do medicine next? Wasn't he operating without a license in that? And like he did an okay job, I think.
He
like
did
actually
fine.
treated some patients. Yeah.
Yeah. So I'm not going to go practice
No.
medicine now, but I did the Frank Abagnale study for 3 weeks and I passed the bar.
That's such a good reference. I need to go rewatch that.
That was such a good movie. So it was a lot because Florida has certain aspects of the law that they focus on, like taxes and constitutional issues that really don't come up at other places that other states don't really care about. A lot of trust in estates. So I studied, and then you have to go physically and take the bar, and it's not like this uniform bar. It's like the old school 1 day Florida, 1 day MBE.
So you took the whole thing, basically.
I took the whole thing, and I went. They make you show up a day early in the Tampa Convention Center to pick up your pass. So you have to go there and stay there for 3 days to take the bar there. And between Barbary, they also charge you extra fees if you're practicing for more than 10 years. I also signed up late and I wanted to use my laptop, which is an extra fee. Between all of those things, plus the travel, it was 10 grand. It was a lot. It was a lot to do it.
You get one case, it'll pay for itself.
Yeah, I had the firm pay for it, so it was fine. But I went, did it in the convention center. I'm waiting on the line to get in on day one. And this woman in front of me tells me she took it in July. She's been practicing for 15 years. She took it in July and she failed. And I'm like, why, what was the focus of the test? Because there's different every time. You don't know what the focus is going to be. And she's like, oh, it was trust in estates. And I flunked that. I'm like, what do you practice? And she's like, trust in estates. I'm like, oh man, this is going to be tough. And then it was trust in estates again on my test, but thank God I passed.
You think she passed?
No idea. But I got it. And then I had to also take the MPRE when I came back.
What is that, the professional responsibility part?
Which I found much easier this time around. I guess I'm more ethical than I used to be. So I took that again. So in total, it was 3 different test days and a lot of money. And you had
to spend 3 days in Tampa.
Yeah, I did.
Which Lee and I have gone down there a couple times. I don't know if I'm missing something, but it's not really someplace I'd want to spend more than 2 days.
I mean, the JW Marriott was fine, but otherwise.
Good cocktails at the lobby bar.
I went to the executive lounge and did the studying there, and they have snacks all day, and I just pounded those snacks. So
all right. So you got that out of the way.
I got that out of the way. And now,
have you showed up in court in Florida? Like, are you?
Yeah.
Again, I'll tell you I argued a case in Jersey one day, a couple of years ago. It was just over the river I guess it was Hudson County. Not geographically very far, but I walked in there and I felt like, something like this isn't my home jurisdiction. I've never seen these judges. I don't know where to stand. I don't know. You wait outside the courtroom. Like it just felt like all the little intangible things, and it went fine. But at the moment I was sort of like, I don't know the cultural, just how do you act in the courthouse? Have you encountered, I'd almost be more worried about that. Because you can look up the rules, you can look up the procedure, you can research, the practice of law is open book, but where to stand is kind of not.
So I got a little help in that respect because we have an office in Miami and I have colleagues who practice there. So, I got a little help from them, but I've learned. I mean, now I've been there's only 2 complex business division judges in Miami-Dade State Court.
What is that? Miami-Dade
Commercial
Superior
Division.
Court, or what do they call it down there?
Oh, it's the circuit court for the 11th Judicial Circuit. But
so you've been in front of these judges.
I've been in front of the judges. I've learned them. I've learned, their different practices and stuff. I got summoned by a judge. A judge wrote an order saying David Kupfer shall show up in my courtroom Monday morning at 8 a.m.
Because you screwed something up?
Well, because he thought I was screwing around with discovery on a case.
Oh, that's good.
So he summoned me by name.
So you jumped on a plane on Sunday?
I jumped on a plane and I went down there. And then when I explained the situation, he was like, okay, fine, you're not in default and I'm not going to mess you over. And I was like, and Judge, by the way, I live in New York, so I really don't appreciate being summoned.
Did you say that?
I felt like I had won the day already. So I told him that and he's like, well, thank you for telling me that. But as a practice, I call people down in person for discovery disputes because I find that when I do, sometimes they resolve beforehand. But it's good you told me that you live in New York.
There's a rhyme or reason to it sometimes. We have a case in Tampa and we went down recently, flew down, 2 lawyers, the whole thing. And we're in the courtroom. It's an hour. It was a Daubert thing. It was a pretty weighty thing. We were glad to go down for it. And at the very end, the judge made some remark that was almost like, "Yeah, I would have done this remotely." And I was like, should I have right? Like, and then he was like, "We might have to have another hearing." And then I took the opportunity to say, "Well, would you be receptive to doing it remotely?" And he said, "Of course." But yeah, you're the New York guy. You don't want to rock the boat too much and have them punish you because
Well,
I've experienced that a little bit before. Have
they
you? Have
they
you
do
got?
punish me a little bit sometimes. I had a case that was heading to a trial, and I had to withdraw for the the normal reasons why you withdraw as counsel. I had to withdraw, and the judge denied my motion to withdraw because we're 3 weeks out from an evidentiary hearing. And then I made a request to do it by Zoom, and he denied that as well. We ended up taking it to the appellate court and got out of the case.
On
But
like an expedited basis?
yes, well, the appellate court stayed the hearing once we filed a motion to get out. So
$28,000 in uncompensated fees later, you got out.
probably more than that.
So I'm curious. We've talked, obviously, I mentioned before that you and I kind of have this, like, we formed our own 2-man committee to like overhaul the New York court system. One of the things that we always talk about is some judges, like, they respond to things very quickly. You can write a letter, you'll get a response. Some judges, you could be like, "Hey, I'm in a burning house and I need you to show up with a bucket of water," and they'll leave you hanging for 6 months. How does that compare to Florida? Like, is it the same mixed bag? Are judges more attentive, like, or something else entirely?
Well, I think for the most part, the business division, the complex business division judges are on top of their game. But if you want their attention, you need to learn how to get their attention. So the judge there's this one judge that I've been in front of maybe 3 or 4 dozen times now. And every time he's like, "Well, if you have trouble with this kind of issue, like scheduling something with opposing counsel or whatever, then you should just email my chambers," right? Except that he doesn't even realize the emails to his chambers go nowhere.
Yeah.
So he has twice a week at 8 a.m. 5-minute motion calendars where you're join on Zoom. It's a calendar call. There are a lot of people on twice a week in the morning, and he gives each side 2.5 minutes, and you literally see a clock on Zoom, 2.5 minute countdown for each side,
And do you
and
have
then
to
he
file
just
something in advance?
yeah, you could do, but they're easy. They're relatively easy to schedule and to get on there, and he has a lot of capacity because he goes for like 90 minutes, so he can accomplish a lot of motions in that 90 minutes. And so if you want his attention, that's the right way to do it. Writing an email to chambers gets you nowhere, and it took a little bit of time to figure that out.
I've never heard of a judge in New York doing that. I can tell you that it seems like a lot of judges in New York are doing things that are incredibly inefficient. That sounds like basically open court.
Well, it is and it isn't, because he actually takes 4 or 5 hours the day before to read all the papers. So that 2.5 minutes each side is enough. And even something like a motion to amend the complaint, he'll do in the 5-minute motion calendar. He doesn't require a longer hearing because he's read the papers, and sometimes he'll even just jump in with his question.
Can you get more time if, like, that seems like it would be a good one. Like, we're having a fight about where's the deposition going to take place. There's a guy in North Dakota. These things, like, there's always this gray area. Jump on for 5 minutes, let him split the baby and move on. To me, that sounds like it would be a great way to resolve something like that. But if it's a summary judgment motion with 180 pages of briefing, like, can you?
Yeah, you get more time. Yeah. You do something called a special set hearing. You can get 30 minutes, you can get 60 minutes, and it's all based on agreement of the parties and the judge's calendar, but you could put it on and then you're good to go for a longer period of time.
So I want to ask you something totally different. You started a company earlier in your career. Unfortunately, I understand the company's no longer around, so it doesn't have the happiest of endings, but
Well, I think of it as a degree. I invested my own money, and I got a degree in startups, in venture, in fundraising, in all of the different aspects. And that's helped me with my clients. But yeah, I was a mid-level associate at Cooley, and I was having Shabbat lunch by a friend, and he's a physical therapist. And he's like, "I have this great idea for physical therapy on demand service where you go on an app and you can get a physical therapist to your home or your office in 3 hours or less." I was like, "Oh, that sounds like a great idea. It's going to take off." And I sort of bought in as what it was described to me as just being like a silent partner, except that it turns out that my two buddies who were doing it, who were physical therapists, were not very good at presenting or putting things
They
together
thought
like
they
that.
were also the silent partners.
Well, no, they were the operating partners, but there's so much like public facing stuff that I was better at than they were. So I became the face of like the fundraising efforts and marketing efforts and things like that. And it was a big commitment to do while I was also, working, 2,400 hours a year at a big law firm. So it was hard. And we survived for about 4 years. We got the business off the ground. We developed an app. There was a couple lawsuits involved in the process along the way.
Do you want to talk about those, or is
No,
that something you care to forget about?
no, just like the people who were developing our app
Mm.
told us that they were going to they had their own coders who were going to do it. And really they outsourced the entire thing to people who didn't know what they were doing. And it ended up delaying things and costing us some money. So we filed
Oh,
a case.
you were the plaintiff.
Oh yeah, we were the
Ah,
plaintiff.
I see.
Yes, of
I
course.
see. Well, I look at you and I think defense lawyer.
Well,
You know,
I have a plaintiff streak in me.
it is a streak. You need the streak.
Yes.
So something I'm always curious when we do the Two Lawyers episodes is that I like to ask people is, what's your marketing branding approach these days? Business development. Like you're at a much bigger firm than many. You're at big law. Are you what is your how much of your marketing approach is like you personally doing stuff to get the world to see you? How much of it is like firm related stuff? Is it a mixture, or is it passive? Is it active? Like, what do you want to share?
Well, we came to King and Spalding. I came with a partner and with a partner of mine, Jennifer Racine, and a few counsel and associates. And we came as a team. And one of the reasons we came to King and Spalding was because of their really strong transactional real estate practice. And so part of the business is cross selling within the firm and networking within the firm, and that's been very good. And there's a lot of institutional clients there, so the transactional funds and real estate group has been sending us pretty consistent work. But I love to go out there and pound the pavement myself. I do small group dinners. I go to smaller quality events. I don't really like the big, CREFC and things like that, the big conventions. It's too overwhelming for me. I don't really have quality conversations there. So I do smaller events and I like to meet people.
Yeah.
But I find that when I do that, it takes a long time to develop a trusted relationship that yields business, if it ever yields business. I had a guy that I was referred by a former colleague of mine when I was at Cooley. He referred me somebody maybe 3 years ago. It took 2.5 years to get a paying matter for the guy. And when it came in, it was great. And we had developed this trusting relationship, but it was over 2 years of talking to him, giving him free advice.
Yeah, what did you do in those
those
2 years? I'm curious.
I vetted a number of ideas that the client had about.
But he reached out to you, hey, what do you think of this? And it never really turned into something.
He reached out to me at first because I was at the time at Kasowitz, and an old mentor of mine at Cooley referred him to me because he wanted to go sue a law firm. And most big law firms don't sue other law firms, but Kasowitz would. So I vetted a matter. He wanted to sue a big law firm. It turns out that I didn't think that was going to really go anywhere. Then I vetted another matter for him that he ended up giving to somebody else because it just made more sense. And I ended up doing some, he was thinking about a whole host of other things, some whistleblower stuff. And I vetted work for him along the way. And it never materialized into anything until he came to me and said, I actually have this pending arbitration that's been in abeyance for a few years, and I want you to pick it up and finish it. So I picked it up for him, finished it for him, and it was great. It was a wonderful relationship, but it's a huge amount of time and investment. And there are plenty of times along the way where I was like, I actually think that I need to limit the amount of time I give this guy because it's too much and it hasn't yielded anything. Yeah. But I kept with it, and it ended up paying off. So
patience and generosity with your time within reason.
Yeah, and my rates are such that people really want to hear from me what my strategy and analysis is going to be before they ever sign an engagement letter.
Yeah, you got to be careful with that, right? Because a lot of clients are totally happy to keep you roped in, and hey, what do you think of this? And now they're sending you documents, and they want a follow-up call, and you kind of have to eventually put your foot down gently, maybe. If you want to.
it's a balancing act. You need to evaluate every situation. You think it carefully through. But yeah, plenty of people will get on the phone with me, send me a whole bunch of documents. I'll look at it. And then I get back on the phone with them and I'm like, listen, this is in my wheelhouse. I have a strategy for this. I have an analysis for this. I'm happy to give it to you. But one thing you should know is my rates are really, really high.
Yeah.
So you got to go into this knowing that. And if you're okay with that, then you can, we can work together and we can make it great. But I'm not trying to loop people in with a lowball budget or, anything like that. It just doesn't make sense. The first couple of bills will come in and it'll break.
No, I totally agree with that. I had a situation where the first time I got like a really good lead early in my career, I brought in I don't know what to do with this, right? I brought in a senior partner. We sat down with the client. He starts hitting them with, oh, you've got to be prepared to invest, 250 grand and that'll get you through the first. And I'm sitting there, I'm like, shit, why is he telling them that? And they wound up not retaining us. And I was like, actually kind of pissed off for a little while. But I look back on that and I think, you know what? Smart lawyers will do that because you don't want to go. And I'm sure there are plenty of lawyers that will go in and, like you said, loop you in, rope you in, don't talk about cost, give misleading impressions of cost. And then it's like the relationship is sour very quickly.
Yeah.
Once you hit them with this is what it's going to cost. And if they still want to do it, then you've got a great starting like base for the relationship because they know what they're getting into. You've been honest. They can afford it. And you lose some along the way, right?
You definitely lose some along the way. You're also going to have clients who say, yes, I understand what your rates are, and are still going to be like, wow, I wasn't expecting this. But that's always going to happen.
Yep.
You do your best and, you work with people. And we always like to say, we're very commercial and we'll work with you and we'll figure it out when we run into an issue.
Yeah.
But the fact is that we don't control the rates. We can, we have a little bit of discretion on discounts, but it has to make sense for everybody. But we do good work. I mean, there's a lot of litigators out there who do commodity work. This is very good work, and the results, speak for themselves.
Well, that's a good segue to a question that I want to ask you before we close up here that I probably should have asked in the beginning. Tell me a little bit about your practice. What are your specialties? You and I have talked about real estate litigation a little on the side. Is that your bread and butter? Is it something else? Like what's keeping you busy? And then like what are you excited about? Like what kind of cases do you like to work on and sink your teeth into?
Sure. So I got my start when I was at Sullivan and Cromwell doing financial services litigation, mortgage-backed securities litigation, and I really broke my teeth learning how to practice on those kinds of cases. I went to Cooley for a long time. I was a generalist. I did, tech stuff, employment stuff, and I learned how to practice in bankruptcy court as well, which has been very, very helpful. When I came to Kasowitz, I really shifted and started focusing a lot more on real estate and hospitality. There's so much in that universe. I mean, it sounds like it's pretty narrow, but it runs the gamut. There's a million things out there. So that's what I'm focused on now. I'll do other work. I just finished a 9-day arbitration hearing on an employment case, and I'll still do stuff in bankruptcy court. I'll do other things, but at least from a marketing standpoint, and what I'm spending most of my time on is real estate related. So I'll do UCC foreclosures. I'll do standard foreclosures. We'll have financing issues, a lot of guarantee cases right now.
You're on the lender side on most of those?
On most of those, I'm on the lender side. And there's a lot of steady, good work there right now. But I like the weird case. I like the case where some city register in the Midwest has decided to reject a $200 million deed for some reason, and you get to fight over something interesting, So I like those cases.
Stuff with no clear answer.
No clear answer, not a lot of precedent. You get to sink your teeth into some interesting issues. Those are fun, and you get that in this world. So we represent a lot of hotels that always have interesting issues, especially right now. I did a 20-day arbitration hearing on a timeshare case. And it was fascinating. And the most interesting part of what I do, what we do, is learning new stuff about new industries, new areas of the law. And I feel like I'm learning new stuff
New
every single day.
CPLR provisions that you hadn't.
Always learning about new CPLR provisions, but even the substantive stuff. The employment case that I just finished trying related, there was a lot of biotech stuff in it and patents, and I never really delved into that, and I learned a lot about the underlying technology to litigate the case, and it was fascinating. I loved it.
It's funny to hear you say that because I think back to like, when you interviewed for jobs when you were like a 2L maybe, or even after like 1L, and they're interviewing you for summer associate job. You're like, I don't know anything. And I would always, my go-to was like, well, I want to do litigation because I really want to learn. Like, I like the idea of learning. Like, I'm not going to be a biotech specialist, but I'll learn like that little area. That was like that was my shtick that I fell back on. And
It's a good
shockingly,
shtick.
it's a good shtick because like all these years later, like that kind of,
It's held
right?
up.
It's held up. You learn enough about real estate lending and hospitality management. All these things were like, you're not going to go write a book on it, but you know enough that you can stand up in court.
Well, you know enough to pass yourself off as an expert when you're talking to the judge. So you really become like a very quick study and an expert on a very specific issue that you need to know. And I love that stuff.
That's the shtick right there.
But the part that the clients hire me for is not that. They hire me for the experience and the know-how to litigate. But I get to learn.
Right. It's assumed that you're going to be a quick study and figure it out. Like that's almost a non-negotiable, right?
Yeah. I mean, the first time I got a nursing home case, the client gets on the phone with me and he's like, all right, so there's the OpCo, the PropCo, the management company. And I'm like, yep, absolutely. And I had to go Google what these things are and figure it all out.
Mm-hmm.
And, once you figure it out, it all makes sense.
When you're forced to learn, you figure it out. Like the same way, like, you don't know how to drive somewhere because you're always I went away with my dad and he's like, you don't know where the hell you're going. I'm like, you're driving the whole time. He's like, oh, I was kind of like, oh, that's a life lesson. When you're forced to know, you figure it out, or you gotta figure it out really quickly.
I was talking to my 16-year-old's learning how to drive right now, and I was in the car with her the other day, and I was like, there was a time before GPS. She's like, how'd you get anywhere? I'm like, that's a great question.
Yeah, I delivered pizzas one summer.
I have no idea how I got anywhere.
You called people, you wrote things down.
You stopped and asked for directions on the way.
Yeah, exactly. Yeah. Well, this has been a really fun chat. I hope we can do it again sometime, and we'll continue our two-man
gripe sessions.
Let's think of it as a two-man committee to improve the New York court system. How about that? And we'll meet again here in this booth in 6 months.
Sounds great.
All right. Thanks for coming on, man.
Of course.
For more on all things real estate and the law, subscribe to this and our other podcasts. Follow Bergstein, Flynn, Knowlton, and Pollina on social media. Subscribe to our newsletter and go to bfklawoffice.com. That's bfklawoffice.com to learn more.